Good afternoon, and thank you so much for joining us today. Whether you are new to B&B or maybe you just need a reminder, I don't want you to forget about our website at bradfordbarthel.com, where we offer lots of information and value-added services. I want to remind you about just 3 of our services today. We have over 50 continuing education videos for viewing with your CE units due, I think, in June. If you are short on credits, you can take advantage of our website by watching some of those and earning those certificates. Our rating department is available to you whether you need a detailed PD rating or even just a rating string. And finally, our B&B blog, we release an average of 2 articles a week on timely workers' compensation topics. And we have a couple of new articles that were posted just this week. So check out our blog if you get a moment today. Louis Larres is an equity partner and the director of our Appellate division. He's going to be leading today's discussion on demystifying appellate procedure in workers' compensation cases. But first, as you can see, we have a wonderful team of B&B attorneys who would love to say hello. And we're going to start with Alec.
Sure. Hello and aloha. My name is David Alexander Pendleton. I go by Alec because we have a number of other Davids here at Bradford Barthel. I've been with B&B since 2015. Prior to that, I worked in Hawaii, first as a workers' compensation attorney for injured workers. So I represented injured workers, then served in the legislature, and finally was a workers' compensation judge on the Labor Appeals Board, adjudicating workers' compensation appeals. Returned back to California here in 2015 and joined Bradford Barthel, where I'm a partner. And a fun fact is I have 4 kids. One is a work comp defense attorney who got hired by colleagues of mine who are on the other side of the aisle, but apparently they liked my work and hired my daughter despite me. So pleasure to be here. Glad that you're here to sign in for this this informative seminar webinar. Louis is very experienced and will give you a lot of very useful information.
Thank you, Alec. Deborah.
Good afternoon, everyone. My name is Deborah McPherson. I have been practicing workers' compensation since 1989, when I started at a smaller defense firm. Like Alec, I have done both sides of the fence. I've worked representing applicants as well as the defendants. I spent about 24 years with Liberty Mutual in-house with one of their offices, and I recently moved over to Bradford Barthel in January of 2022. I'm looking forward to meeting all of you and working with all of you. I enjoy making homemade pizza, everywhere from the dough to the sauce to, I don't do the sausage or the cheese, but everything else I give it a shot. And I like baking in general. And one of my passions is actually kickboxing. So my husband has to watch out every now and again. I just don't, elbow him. But we want to let you know that if you have any questions regarding one of your cases or just a general workers' comp question, that you're always free to reach out to one of us and we'll be happy to give you some assistance.
Thank you. Tamina.
All right, everybody knows me, so I don't think an introduction is necessary, but I have a joke for Alec. Alec, did you know that you can't laugh loudly in Hawaii?
No, I didn't know that. Why?
Because all you can do is aloha. Okay, with that, we know we're missing Don today and his bad jokes, so I had to fill in. My name is Tamina Ahmed, and I'm the managing partner for client relations with Bradford and Barthel, as the PowerPoint says. My cell number is available on the website, so please feel free to call me on the cell. Look forward to meeting all of you in person someday soon. I'm down in Southern California, but before COVID, we were traveling all over the place, so I can be anywhere, anytime, be available to you as an additional resource from the firm. I've been with the firm for 24 years, and the firm is celebrating its 25th anniversary this year. So thank you to all for being our loyal friends and clients and customers, and we look forward to the opportunity of working for you And with that, I'm going to pass it on to Louis Larres, who will entertain you just as much as the Oscars have entertained you, I'm sure. But it's going to be a fun show. Not that much fun, but it will still be a fun show. So with that, I'm going to pass it on to Louis, who I admire and respect greatly. He is one of the brightest people that Bradford and Barthel has to offer. And he is a partner of mine and has been for quite a few years. He's one of the equity partners, as Tammy mentioned. And I'm getting all sorts of weird questions now. They're asking, who is he going to slap? No, we're not going to answer that one. But I will pass it on to Louis. Louis, here you go.
Thank you, Tia. Thank you for that introduction. Good afternoon, everybody. It's a pleasure to be with you this afternoon. And thank you for spending your lunchtime with us. This is a topic I'm very passionate about. My career with in the Appellate Division started with a little case called Guzman, which we argued before the 6th District Court of Appeal up in San Jose, and from there on it was all downhill, I guess. And we formed the Appellate Division, and I've argued numerous cases from recons and removals to petitions for writ of review with the various courts of appeal, and even with the Supreme Court. And so I'll be bringing all of that experience to bear on this topic today. It's one of, like I said, a topic I'm passionate about. And in terms of fun facts, in addition to one of my other passions, I have a rather extensive comic book collection. So I'm a nerd all around. So
you weren't going to say
me. So we'll dive right in. This is just a kind of a smattering or sampling of cases I've handled, some of which are published. The Supreme Court case I mentioned that I argued before the Supreme Court says the top bullet point there, South Coast Framing, involved a death case and the standard for causation. And most of these cases deal with statutory interpretation issues, and I'll talk about why that's important in terms of getting your appeal heard by the Court of Appeal, as opposed to other issues like substantial evidence. But you can, if you have access to Lexis, you can, I was gonna say Google my name, but you can Lexis my name, and you'll find all the cases I've handled with B&B. I've been with B&B for 21 years in total, this coming May. So diving right in, appellate authority. The Labor Code sets forth the requirements for filing for reconsideration or removal. For reconsideration, a party who is dissatisfied with an order of a judge can seek review by filing a petition for reconsideration, with one caveat, that order has to be a final order, which finally disposes of a substantive right in the matter, or it can be a determination of a threshold issue. And so what a threshold issue is, for example, is a causation issue or a issue of nature and extent sometimes, or it can be a jurisdictional issue if you're arguing that the board issued an order where it did not have jurisdiction, such as an ADR case or an MPN, or not an MPN, but a medical treatment dispute. If one of your arguments is that the board does not have jurisdiction, that can also be a threshold determination. And so if you have a decision that is not final, and we'll talk about the distinction between final and non-final in a moment, that also determines what type of review or what type of appellate matter you should be filing as opposed to reconsideration. And decisions of the WCAB are subject to appellate review by means of a petition for writ of review with the Court of Appeal and the Supreme Court. In fact, 5950 says that you can go directly to the Supreme Court, but I have never seen that done in my career. And more often than not, if you were to do that, I would anticipate the Supreme Court kicking it back down to the Court of Appeal that has a jurisdiction over that case to first weigh in and decide the issues raised in that appeal before the Supreme Court granted review in that situation. So one of the factors in seeking reconsideration is the requirement that the party be aggrieved. And in order to be a party, you have to party imposes standing on that person or entity to seek review. And so a party can be an injured worker, a dependent in a death case, the employer, particularly in 132A and S&W cases, the insurance carrier, more often than not, and a lien claimant, or if they're not a lien claimant just yet, a cost petitioner can also be a party. And if they're adversely affected by that decision, they can then seek, or are entitled to seek, reconsideration. So as I mentioned, a petition for reconsideration requires a final order. Again, that's something that disposes of a substantive right, a right that affects a party's entitlement to benefits. So if there's an award of temporary disability, or an award of medical treatment, or an award of permanent disability, those are substantive rights and subject to reconsideration because they are final decisions. You no longer, thankfully, to Eames, you no longer need to file with the district office where your case was tried. The time limit, and this is probably one of the most important takeaways, for filing reconsideration and removal actually, is 20 days from the date of service. So that imposes an additional 5 days for mailing. And thankfully, the 5 days for mailing also includes if the decision is served on you electronically. So it's a total of 25 days from the date that that decision is issued, by which you have to file for reconsideration or removal. And that 25 days is jurisdictional, meaning if you file on the 26th day, or if you file at 5:01 in Eames on that 25th day, it is late, and it deprives the board of jurisdiction to hear that dispute. And if there are parties out there who mail instead of are e-filers, it has to be received and in Eames essentially to be deemed filed. Otherwise, if it's just been mailed, that's not sufficient to constitute filing for purposes of satisfying that 25-day time period. Really quickly, there are some formalities with regard to service. All parties who are adverse to the petition or the issues you are raising have to be served. Failure to do so can result in a dismissal of the petition. So it's necessary to ask yourself when filing a petition for reconsideration, whose interests are adverse to the relief I'm seeking here. If you're disputing an issue of temporary disability and EDD is paid a lien, then EDD could potentially be adversely affected by the outcome of that decision. And so EDD would have to be served with that petition as well. And of course, a proof of service indicating who you've served and that the petition was indeed filed is required. Next, and perhaps just as important, are your grounds for reconsideration. And there are 5 that the Labor Code specifically sets forth. And so the first one is an action in excess of the powers of the board. And so typically the types of issues that fall within that category are, as I mentioned previously, issues of jurisdiction. If you have an ADR case and you're arguing that it's subject to a carve-out, or if you have a timely UR, or at least a UR that you're contending is timely, and it's subject to UR, an IMR, or a bill review. If the cost petitioner or provider fail to seek second bill review timely, then arguably the board in those situations doesn't have jurisdiction. If they issue a decision granting relief for that lien claimant or for the applicant in that situation, then arguably they've exceeded their jurisdiction, they've exceeded their powers, and that's your cause for seeking reconsideration. The second ground is fraud, and that fraud must go to the procurement of the order or decision or the award of benefits. If you're alleging fraud, the Labor Code imposes on that party making the allegation the duty to specify and to set forth in detail what that offer of proof is and how that fraud goes towards the outcome of the case. Now, the most common basis for seeking reconsideration is that the findings are not justified by the evidence. This is your substantial evidence argument, essentially. And again, the petition has to specifically set forth in detail how that evidence fails to support the findings. And just as a catch-all, really, the board disfavors skeletal petitions. So if you simply say that the findings aren't justified by the evidence, and you fail to set forth in detail why that evidence doesn't justify the award, then you're subject to immediate dismissal without a decision on the merits. Fourth is that newly discovered evidence. And the Labor Code sets forth specific requirements when raising this type of basis for reconsideration. If you can, you have to demonstrate that the material or the evidence could not have otherwise been discovered in the exercise of due diligence. And so you will sometimes need to have an affidavit of either the adjuster or another party, if it wasn't the handling attorney, setting forth why that evidence could not have been obtained prior to the closure of discovery pursuant to Section 5502. So if you are alleging that there was a witness who you just discovered after the fact, or there is documentary evidence, you need to describe that evidence or describe that testimony from the witness as well, in addition to why it could not have been discovered previously, and then explain the impact of that evidence on the potential outcome of the case as well to obtain relief. It's not, ideally, this is not a ground you should be raising because you should have, again, exercised due diligence and obtained that evidence. And so it's kind of the five grounds, it's probably the one with the highest of bars to satisfy in terms of getting the board to grant relief. And then fifth and final, one that I've maybe used just a handful of times, is that the decision is unsupported by the findings. And it's, again, not a defect that occurs frequently. Sometimes you will see it used if the judge fails to correct a clerical error in the award. You can raise this basis for reconsideration to get the judge to correct it. It's sometimes also used if the judge relies on the opposite side's evidence, but issues an award that's in your favor and the other party's favor, relying on the evidence that doesn't necessarily support that finding. So upon your filing, let's say you've set forth your grounds, it's timely filed, you've served the proper parties, there are a number of outcomes initially that the judge can take, the trial judge, that is, when in receipt of a petition for reconsideration or removal. So the judge can issue a modification of the decision. He or she has 15 days from the date of filing of the petition to do so. After that, he loses or she loses the right to modify the decision. The WCJ can also rescind the decision and order then further proceedings. And those further proceedings have to take place within a certain time span of the order rescinding. And that's one of my favorite things to happen. It does happen on occasion. I actually had a judge who I will not name call me up on a conference call and apologize for failing to realize that he could not award 15% bump up on a permanent total disability award. And he even disclosed to me that he had circulated the question with a couple of other judges at the district office where he worked, and they all gave him the same response, that he could impose the 15% bump up. And when I cited clear authority that was contrary to that position, he rescinded his decision and set the matter over for further proceedings in that instance. So if the judge, oh yeah, question?
Pardon me for the interruption, but
sure.
This kind of goes more into the VR category of things, and there's a question. The question is, does the board have any jurisdiction over rehab issues? And the asker is asking that a lot of DAs don't recommend any VR rebuttals because the applicant's attorneys continue to get VR experts. Now, I don't like going in without a rebuttal, so I'm not sure which DAs are doing that, but it shouldn't be. We should always go in with evidence. So I guess the main question is, does the board have any jurisdiction over rehab issues?
Well, I think maybe what that question is implying, there was due to the enactment of 4660.1 and the new schedule and the omission of the phrase loss of earning capacity in terms of what makes up permanent disability. A lot of defense attorneys, and I think myself included in at least one instance, argued that the vocational rehabilitation reports were inadmissible, and the board has pushed back on that, saying no, that's not correct. And so to your point, Tia, yes, when I see a vocational or a VR expert report on the other side, I tend to favor getting a rebuttal report rather than going in empty-handed, unless I know for certain that VR expert is clearly not substantial evidence or failed to review key records. So you take it on a case-by-case basis as to whether you want to get a rebuttal report. But yes, they are admissible still in post 1113 cases for which 4660.1 and that schedule is applicable. So hopefully that answers your question. If there's any other follow-up questions, feel free to chime in.
Sounds good. Thank you.
Sure. So if the judge does not rescind, does not modify the opinion, and they can then issue, or they're required to issue actually, a report and recommendation on reconsideration. And that's typically where a judge will fill in some of the holes in their opinion on decision that accompanies the findings and award. And in cases where they don't usually do, because they're pressed for time in most cases, where a judge fails to issue a very thorough opinion on decision, and you point that out in your petition for reconsideration, they can then remedy that, and then the law recognizes that ability to remedy the failings or the shortcomings in the opinion on decision by means of the report and recommendation on reconsideration. And again, they have 15 days from the date of filing to do that, and more often than not, that's the course they take. And then finally, once the judge has issued his report and recommendation on reconsideration, the WCAB, the matter is transferred up to the WCAB, their reconsideration unit up in San Francisco, and they can either grant the petition or deny reconsideration, and they have 60 days from the date of filing of the petition for doing so. Failure to deny or grant within that 60 days constitutes a denial by operation of law. However, I have yet to see the board ever do that. And more often than not, if they cannot get to the merits of the case, they will issue what I call a pro forma order granting, where they grant just to satisfy the 60-day time requirement and indicate that they're going to study the issue further. And then all bets are off as to when they get to it. I have had a case, I still have a case sitting up there going on, I think going on 3 years now. That's a worst case scenario. But in fact, that it must be getting bad, because I'm aware of a defendant filing a petition for writ of review, arguing that the board's pro forma grant of reconsideration without an actual decision on the merits violates that rule, and we'll see what the Court of Appeal does with it. But I'll be very interested to see if they take that up. So as I mentioned earlier, the judge can modify or rescind or amend, and what the judge does in that instance really does kind of is important, because it does determine whether or not you've got a new decision, and thus a new 20 plus 5 days for seeking reconsideration, or whether or not it relates back to the original F&A, and whether or not you're still under that original 20 plus 5 days for seeking reconsideration. As I mentioned, the judge can rescind the decision. When they do so, rescinding is essentially voiding the decision, meaning it's of no effect any longer. And then the Labor Code imposes upon them the obligation of setting the matter for a status conference, usually within 30 days of that order rescinding, to then sort of meet with the parties and work out where the case goes from there. So as I mentioned, simple modifications or amendments to an order do not require any additional proceedings. The judge can simply do so without requesting a status conference. But bear in mind, if it's a clerical decision, as I mentioned earlier, if it's merely clerical, then that does not extend the time for seeking reconsideration. If it's a substantive modification, then that does start the clock over for seeking reconsideration in that instance. And the Labor Code also authorizes the adverse party to file an answer. And I recommend, as a point of practice, filing an answer in every case. I've seen one case, for instance, where a defendant did not file an answer, and the judge in his report and recommendation actually recommended that reconsideration be granted. And so the board took that as that silence on the part of defendant as acquiescence to the judge's recommendations, granted reconsideration. And so it's always best practice to put your arguments forward. I always try to beat the judge to their issuing their R&R, their report and recommendation, so I can kind of feed the judge what I want the judge to say. And it's always nice to see them sometimes adopt some of the language or some of the arguments that you raise in your answer in their report and recommendation as well. So the appeals board itself is just some interesting tidbits, if you didn't know already. It's made up of 7 members, 5 attorneys. The law actually allows the governor to appoint 2 who do not have to be attorneys, and Jerry Brown was famous for doing so. He appointed a longtime friend and a choir director, or a former choir director, I should say, as a commissioner, and who had no legal experience whatsoever. So they're appointed for 6-year terms, and they're all commissioners, and the head of the 7 members is known as the chairman or chairperson, who leads the board. And so the every petition for reconsideration is handled by the district office initially. So the judge can then issue their R&R. Once the R&R is issued, it's tasked or transferred electronically to the recon unit through EAMS, and that's how the recon unit is aware that there's been a petition filed by means of the control unit. And most cases that you file reconsideration or removal on are assigned to a panel of 3 commissioners, and that's a panel. That decision that issues is known as a panel decision. And the reason that that's important is because, as we'll talk about in this next slide, the panel decision is only binding on the parties to that case. So if you're not a party to that case, that decision is persuasive authority, but it is not binding on other litigants and other cases. The one exception to that is Inbank Decisions, or en banc if you're French and snooty. An en banc decision is a decision where all 7 commissioners sit in and decide the issue, and they will usually do that to decide novel issues or issues that they see come up time and time again, where there may be a split of authority in some of the panel decisions. In fact, I just filed a petition for reconsideration today on an issue where there is a bit of a split in authority, and the board has been dealing with this issue for some time in terms of in-house rehabilitation care and whether or not utilization review is proper in cases where the requests for authorization are time specific. So I'm hoping that given the split of opinion among the panel decisions, the board will take this up and maybe issue an in-bank decision. So your other typical in-bank decisions, and they're published on the WCAB's website if you want to access those free of charge. They are there. But you've got your Alvarez Guzman, of course, Dubon regarding medical treatment. And this year, actually 2021 was relatively silent in terms of, I think due to COVID, in terms of in-bank decisions. They did issue in-bank decisions, and I'll put that in air quotes, because they had to deal with procedure at the board due to COVID. And so they issued a number, I think 6 in total, which they adjusted over the course of time as conditions changed. But no other in-bank decisions from the board in 2021 that dealt with substantive legal issues. So as I indicated before, the board can grant or deny reconsideration, and they're authorized actually quite broadly to review the evidence, substitute their own findings for the findings of the judge. And a lot of people think that the trial judge his opinion on the credibility of witnesses is sacrosanct. Actually, it's not. And I've had the WCAB, when there is clear and convincing evidence otherwise, rule that the judge's findings of credibility were not to be given the great weight that they typically enjoy, and reverse the judge in that one instance. It is rare, but they can make determinations on credibility basically across the board on all the evidentiary issues, and again, substitute their own findings for that of the judges. They can also remand the matter back for further proceedings, as they sometimes do, and direct the parties to develop the record on specific issues if they feel that one side has not presented substantial evidence on an issue. So as I mentioned before, time limits. The board does have 60 days from the date of filing of the petition to issue a decision. And again, they do work around that by issuing these orders for further study. And if that happens to you, it has been my practice not to write to the board and say, hey, you forgot about my case. When are you going to get around to this? Because often than not, the party that writes to the board is the party that ends up ultimately losing the case. So in a rare instance, I may do so, but usually it's just best to sit tight and wait for the board to issue a substantive decision on the merits. It's also an opportunity to revisit settlement, and that can be a good opportunity to try and settle a case if it's going to sit up at the board indefinitely. Let's see. So other considerations besides petitions for reconsideration are petitions for removal. Knowing the difference is key. Like I said, if your decision is final, then you're free to file reconsideration. If it is a non-final, and your examples of non-final decisions are issues regarding discovery. Those are the bulk of your non-final issues or disputes. if you've got a QME specialty dispute, if you've got a deposition dispute or a record discovery dispute, those are all non-final and are subject to removal. And the standard on removal is quite different from reconsideration. You basically have to show that by virtue of the order, you as the aggrieved party will suffer substantial prejudice or irreparable harm. And in my experience, cost to the when you're the defendant in a deep-pocketed insurance company, cost is not a factor that the board will recognize as irreparable harm or substantial prejudice. So it's got to be a right that is affected, essentially. And in the cases where I have gotten removal granted, it's because there was a denial of due process, or there was some other statutory right that the judge was stepping on. And in those instances, the board will grant removal because there is substantial prejudice in those cases. The other important thing to remember is that a petition for removal, unlike a petition for reconsideration, does not stay the proceedings. So a judge is free, after consulting with the PJ, a judge is free to go forward with whatever issue you're disputing. And so just because you filed a petition for removal on a panel QME dispute, the judge can still go forward, and the applicant can still, or the other party on that QME dispute can go forward with that QME evaluation. And so that brings me kind of to one of the other petitions I filed. It's not really an appellate petition per se, but it does kind of flow nicely with a petition for removal for that very reason, because it doesn't stay the proceedings. Is a petition for oh, I failed to list it here, actually. My apologies. I think I've got it listed somewhere else, but this is a good time to bring it up. It's a petition for emergency stay, and it's again authorized by the regs, and it's a stay of a party's effort to do something that you feel is either wrong or impermissible, or is subject to a pending petition for removal, let's say. And so in those instances, I will file my petition for removal, and if applicant's attorney continues with that course of action that is the subject of the removal, I will file a petition for emergency stay. And in most cases, the judges will grant them, or they will set it over for a hearing to allow for a further argument and decision on the merits of that petition for stay. And so that's another tool to keep in your back pocket. So some other considerations that are appellate related: petitions for automatic reassignment. It used to be that when you filed a petition for removal on issues of causation or jurisdictional issues, and it was remanded back, that the matter was automatically reassigned to a new judge. And that's been modified. So you now have to petition for automatic reassignment, and it's usually for issues related to the judge's conduct, if there's bias, and ideally that bias should be on the record in order for you to be able to prevail on a petition for automatic reassignment of the judge. And then a supplemental petition. The board typically disfavors additional filings once you've filed a petition for reconsideration and the other side has filed an answer. I have on a handful of occasions filed a supplemental petition where, for instance, the judge raises an issue, or the applicant's attorney in their answer raises an issue that wasn't really addressed in my petition for reconsideration, wasn't raised by any of the parties at trial. So it's essentially a new issue, and due process, of course, mandates that you be given an opportunity to respond and rebut that. And so in those instances, the board has on occasion granted my request for supplemental filing after I filed for reconsideration. Now, further judicial review. If you've lost at trial and lost on reconsideration, you can pursuant to the Labor Code, file a petition for writ of review. And again, a petition for writ of review requires a final board order. And so knowing again what is a final decision is key here. It is filed with the Court of Appeal that has jurisdiction over which the district office of the WCAB sits. So if you're here in Fresno and you've got a Fresno decision, then you would file with the 5th District Court of Appeal here in Fresno. The time limit for filing is a strict 45 days. You do not get an additional 5 days for service. So you get 45 days from the issuance of that decision. And again, that is jurisdictional. If you file on the 46th day, and again, thankfully, the courts of appeal are electronic. And unlike the WCAB, you can file up until 11:59 p.m. that day. And in one instance, I did have to do that. But again, if you're late, the Court of Appeal loses jurisdiction and cannot hear that appeal. One other thing to point out too is if you have a non-final, let's say you file a petition for removal and it's denied, you do have recourse actually in seeking appellate review, but it's more likely to be a petition for writ of mandate, and it has similar requirements in terms of time frame, but you should file it within 45 days, and you're arguing essentially that the board decision, like you did on removal, will cause you substantial harm, and you're looking for the Court of Appeal to order the WCAB to follow whatever statutory guidance you feel that they violated. So in that narrow instance, you could seek appellate review above the WCAB if you have a non-final decision. And then decisions of the courts of appeal are final within 10 days after the filing of the opinion, unless the writ is granted. And so if they grant your writ and they hear your case, they issue a decision, you actually have 30 days from that plus the 10. So a total of 40 days to seek review with the Supreme Court. Otherwise, it's a straight 10 days. If they deny, as they often do, the Court of Appeal usually issues because workers' compensation, unfortunately, is not high on their list of priorities. They will issue what we call a postcard denial, where they simply say in one line on one page, the writ of review is denied. If they're nice enough, they'll say the writ of review has been reviewed and is denied. So at least you know they've read it. But really, in order to, and we'll talk about this, I think, in a couple of slides, you really have to have a statutory issue, a legal issue, for the Court of Appeal to consider that it's worth their time to look at and take up. So again, the grounds for appellate review with the Court of Appeal are very similar. The board acted without or in excess of its powers. The decision was procured by fraud. The decision was unreasonable. That's your substantial evidence argument, again, which is not the greatest argument to make on appeal. The order, decision, or award was not supported by substantial evidence. And if the findings of fact are made, such findings of fact are not supported by the order or decision, or do not support the order or decision or award under review. So as I mentioned, the Court of Appeal typically denies these out of hand. And since they don't actually issue a substantive decision, the writ denied version of the WCAB's decision is still citable authority. Again, it's a panel decision ultimately, so it's persuasive authority and it is citable. But it's not a decision of the Court of Appeal on the merits, even if they simply issue the postcard denial. If they do grant the writ, both sides are usually invited to offer oral argument. If the opposing side does, then I, of course, will go to offer rebuttal. And then the court has 90 days from the end of oral arguments to issue a final decision. And the decisions are, of course, written in a formal written opinion, either affirming or annulling the decision of the WCAB. And one of the considerations that I almost always address with a client in making or helping them make that determination on whether to take it up to the Court of Appeal is the potential for bad case law. Most clients don't like to have their names associated with a published decision that is binding on everybody. And so that's a valid consideration to look at and address what the potential is for making bad law. The other consideration is the cost. The opposing or applicant's counsel actually is the only party who's entitled to costs associated with the answer to a petition for writ of review if they find that if the court finds that the decision is without merit, that there's no reasonable basis for taking that matter up on appeal. And in that instance, they can award applicant's attorney a supplemental award associated with the time spent in preparing the answer to the petition. So that's also another factor to consider when deciding on whether to take the matter up on appeal. So the other question I get asked is, what are our chances on appeal? And so I think the foremost consideration I analyze is whether or not, what's the issue we're raising? Are we raising a question of law, or is this a question of substantial evidence? And so with that in mind, that's usually how I try to frame the issues at trial, and I give that guidance to our attorneys as well on the ground level, but also in framing the issues on reconsideration. If I can frame that as an issue of law and be creative sometimes in doing so, then that strengthens our chances of getting the Court of Appeal to address this. And bear in mind too, if you're raising a constitutional issue, the WCAB is not authorized to address that type of issue by statute. And so that's an issue that if you have that type of issue, that I try to apprise the client of right off the bat, that we're going to have to go to the Court of Appeal to get a determination on this issue because of the nature of that issue. So if you have a question of law, that significantly increases your chances of getting the court to grant your petition for writ of review. And in probably the vast majority, probably 90% or 95% of the cases I've taken up on a writ where the writ has been granted, it has been because we raised a question of law. And the reason substantial evidence arguments usually fail at the Court of Appeal is because of this language in the last bullet point. The court is bound by statute to give great weight to the WCAB's findings on the evidence, and they cannot reweigh the evidence essentially. But they can address issues of substantial evidence. So if you can point out that the facts aren't in dispute, then your substantial evidence argument could be a question of law as to whether or not it's legally sufficient to support the decision. Like I said, sometimes you have to get a little creative. So the court then can either publish, if they grant your decision, they will either order it published or they will issue it unpublished. And the reason that's important is because published decisions are citable, unpublished decisions are not, and you can be sanctioned for citing to unpublished decisions. And they can also partially publish a decision. So parts of their decision may be published, parts of it may be unpublished. And again, the same rule applies in terms of what you can cite to and what you cannot. And so finally, the Supreme Court has the final say on any such disputes. And like I mentioned earlier, if you go directly to the Supreme Court, or if the Court of Appeal issues a postcard denial, the Supreme Court can actually remand it back to the Court of Appeal for them to weigh in and see how they would determine that issue of law. And more often than not, they do that before weighing in themselves, because they don't like to jump in when a lower court has not had an opportunity to issue a decision on the merits. And so if they at the very least feel that your issue has merit and you've got a postcard denial from the Court of Appeal, they will send it back to the Court of Appeal for a decision on the merits. And then the clock starts over again. If you're adversely impacted or affected by that appellate court decision, you can still take it up to the Supreme Court. And the Supreme Court has 60 days to grant the petition, or they can, of course, extend on its own motion. They are the Supreme Court. And as I mentioned, they can remand it, and it's more common for them to do so in those instances where the Supreme Court or the lower court has not done so. If there are no other questions, Tia, anything else?
Wow, you caught me off guard.
Sorry.
You actually finished early. I'm sure everybody's super pleased. There is a question, but I think it requires us to supply the gentleman, Lon Thompson. Thank you for your question. We'll get that answer out to you shortly. I was just typing a response to your question, but we will respond to your question. Since Lewis has nicely finished early, we will let everybody escape early and get to lunch. So with that, I have nothing.
If I could say really quickly, that's my contact information there. I handle questions from adjusters on a daily basis, from other attorneys sometimes as well, from other firms even, on issues, and just to pick my brain, even if it's a case I'm not handling. So if you have a question, feel free to reach out. There's my contact info. You can call me. The best way to get a hold of me is an email, and I will usually respond usually in the same day, unless it's more involved, and I'll let you know, and I'll take some time to research an issue. But I'm happy to opine and help out when I can. So don't hesitate to contact me with any questions you have.
Great. Thank you, Lewis. Thank you all so much for joining us. We appreciate each and every one of you. Take care, everybody.
Bye.
Thank you so much. Thanks, Lewis.